Hello folks, welcome to Radical Freedom. I'm your host, Kurt Waldrop. Today I will be talking about a subject near and dear to my heart, and that's the United States Supreme Court, and why I think there needs to be a major constitutional shakeup in the area of our judicial system. Now, normally I consider myself something of a fundamentalist constitutionalist, but what I'd like is an amendment to change how SCOTUS, that is the Supreme Court, actually works. Now, the attempts of many justices to legislate from the bench have always been an issue. Even back during the time of Thomas Jefferson, there were things going on that he railed against because he thought they were trying to twist and bend the Constitution out of its original context. And let's face it, they have. So let's take a look at a few of the more wretched examples of judicial overreach, some of the weirder cases of the Supreme Court, shall we? Now, this is part one, and you'll notice I am dressed all in black today. It's what I call my Johnny Cash look, and I've got my way cool Constitution tie. You can get a better look at it up there. So I'm doing my impression of a Supreme Court justice. I don't think they ever do that. One disclaimer, I am not a lawyer. I don't play one on TV. I have a lot of friends who are attorneys. I really think that the way our system was supposed to be is mutated into a monster, quite frankly. Back when the Constitution was originally being ratified, Alexander Hamilton was one of the authors of a group of documents known as the Federalist Papers, which were to explain how the Constitution was supposed to work. Now, there was also a group of papers called the Anti-Federalist Papers that are worth taking a look at as well, because they addressed a lot of what people saw as problems with the Constitution that might result in a tyrannical form of government. Many of these issues have actually lended themselves to the government turning into what we have today. But going back to the Federalist Papers, in Federalist number 78, Hamilton wrote that he thought the judicial branch would actually be the weakest branch of government because it would have no soldiers to enforce whatever its findings were. Its money would be given to it by Congress. So, therefore, out of all the branches of government, it didn't need its own set of checks and balances. Yeah, Congress could, in theory, impeach a member of the court for high crimes and misdemeanors. But they didn't mention that one of the things they considered a high crime would be actually completely misinterpreting the Constitution. That was discussed. They tried to impeach a Supreme Court justice once for going way outside of the bounds of the Constitution for a ruling, and that ended up being a debacle for Congress. And we're talking back in 1802, I believe, when that happened. The newspapers had a field day with it. Congress has never again attempted to impeach or limit the power of the Supreme Court in any way. So, in 1803, the case of Marbury versus Madison, Chief Justice John Marshall declared in his decision that the Supreme Court, SCOTUS, has the right to tell Congress what laws were and were not constitutional. Now, the original intent of the Supreme Court was it was the highest appellate court. So if let's say you're convicted of murder and you work your way up through, you appeal to this court and then they move it up to this court. If they decide it's a constitutional matter or something involving federal authority, it could end up in the Supreme Court. They can also say, no, it doesn't belong here. It really wasn't intended to be the final arbiter of what the Constitution means. That was supposed to be the people through their representatives in the Senate and in the House. some guys in black robes were not supposed to be telling us how our government is supposed to be run or making up laws, which they have been known to do. They've been twisting the meaning of the Constitution into an unrecognizable mass ever since Marbury versus Madison, frequently creating law with little or no constitutional justification. Moving up to 1857 in the infamous Dred Scott case, the Supreme Court ruled that a black man cannot even be a citizen of the United States, so they didn't have jurisdiction to rule on it. They did rule that if you go from a slave state to a free state, then you go back to a slave state. If you were originally a slave, you're still a slave. I don't know how they were able to rule on anything if they were not supposed to rule on anything in the first place. But yeah, this was considered by judicial scholars as one of the all-time screwiest decisions of the Supreme Court. Mr. Scott, who, yes, he was a black man, was arguing that once he was taken to a free state, he became free. Well, of course he couldn't, because he couldn't even be a citizen of the United States. He could only be a citizen of a state. Again, I don't know what they were thinking. I don't know what they were smoking. How can you be a citizen of Missouri and not a citizen of the United States? But since he was black, they said he could not be a citizen, and he never could be a citizen of the United States. This case was a direct cause of the Civil War. Where? I don't even know what that means. Let's move along, shall we? Please, someone tell me in the Constitution where citizenship is based on your skin color or your religious beliefs or anything else. You become a citizen either by being born here to legal citizens, at least at the time the 14th Amendment screwed that up too. I don't think it was intended to, but we're going to need another amendment to fix that one. That goes to a different video that we'll do in the future. It didn't prevent the Supreme Court from ruling that they didn't have the constitutional authority the Congress, that is, didn't have the constitutional authority to draw a line saying that you can't have slavery north of that line. They didn't prevent them from ruling that people can't vote to outlaw slavery in their state. It's pretty crazy. A little note: Roger Taney, not really sure, who was, by the way, was a Democrat. Does he look like the star of the movie Nosferatu to you, or is that just me? Anyway, that doesn't matter. Neither here nor there. Now, in a dissenting opinion at the time, Justice Benjamin Curtis said that when a strict interpretation of the Constitution, according to the fixed rules which govern the interpretation of laws, is abandoned, and the theoretical opinions of individuals are allowed to control its meaning, that we no longer have a Constitution. Instead, we're under the government of individual men who, for the time being, have power to declare what the Constitution is according to their own views of what it ought to mean. Amen, brother, but let's face it, that pretty much sounds like business as usual today in Washington, doesn't it? Moving along, I'm going to skip past some of the more pathetic Reconstruction decisions, including Plessy versus Ferguson. That was the one that upheld the separate but equal thing. We're going to move on to the 1930s when the court really started going off the tracks. In 1939, there was a case where a man was caught trying to cross state lines with a sawed-off shotgun in violation of the Federal Firearms Act. When brought to trial, he originally pled guilty. They caught him with a sawed-off shotgun. What are you going to do? But the judge talked him into saying, no. This is actually in violation of your Second Amendment rights. If you'll plead that, I can let you go. Well, the guy's not an idiot, so he did plead that, and the judge let him go. Turns out, though, that the judge was a very staunch anti-firearms guy. He really didn't believe in the Second Amendment, and he thought this was a good opportunity to put to bed a lot of the protests people were having about the Federal Firearms Act. So, as he assumed, the Bureau of Alcohol, Tobacco, and Firearms wanted to argue the case. They took it to the Supreme Court, and little note about this gentleman that they had arrested. He was being sought by the mob because he had turned state's evidence on them at some point. They thought he would go into hiding. I actually found him, dead-ish. And since he was dead-ish, he couldn't pay an attorney to come to Washington and represent him during this case. So you went to the Supreme Court with only one side of a case. I don't even know why they bothered at that point, but oh well. So it's no surprise that the court ruled in favor of the BATF. One of the great gems of this opinion was that the Second Amendment was only written for militias. Now, they completely ignored that George Mason, one of the framers of the Constitution, wrote that a militia is made up of any citizen of the United States. But since it was a military organization, according to the court, only military weapons were covered under the Second Amendment. And sawed-off shotguns are not a military weapon, so therefore the government can control them. So obviously the sawed-off shotgun or a shotgun has never been used by the military. Well, that's the Civil War. Now that's back in the 1800s. Now by World War I, they of course didn't use. Okay, that's a trench gun. That's a shotgun. But what about World War II? I mean, surely in World War. Marines on Iwo Jima using a shotgun. Okay, well, what about modern? The modern military is not in the Marines using a Remington 870 shotgun. Okay, let's pretend we're the Supreme Court and ignore all evidence to the contrary. We're going to pretend that the military does not use a shotgun. Would that mean that they can't regulate the ownership of machine guns? Because last I checked, machine guns actually are used by the military. Of course, let's face it, so are shotguns, but that didn't stop them there. Moving on, in 1942, the court heard a case where a man was accused of, get this, planting too much wheat. The government had set a rule that you could only plant a certain amount of wheat because otherwise it might screw up the market for wheat. This is 1942. World War II had started. People were starving in parts of the world. The U.S. military was needing all the food it can get, but there was a limit to how much wheat you could grow. Now, while this rule was there because they didn't want to screw up the interstate market for wheat, this guy wasn't even doing that. He was planting wheat to feed his family and to feed his cows on top of what he would sell. Well, the Supreme Court ruled, in this case, Wickard versus Filburn. Mr. Filburn did not have the right to plant extra wheat that was only for his family and cattle, because that could interfere with interstate commerce. Seriously. They said that he wouldn't have to buy more wheat then, and that wheat that he might have to buy, if he did have to buy more wheat, might be produced in another state. So that way it falls into the Interstate Commerce Clause and the Supreme Court can rule on it. Based on that, they can rule on anything! Anything! I might scratch myself, and that would be in violation of the Interstate Commerce Clause, because if I scratch an itch, it keeps me from buying some talcum powder that came from another state. What kind of idiots are they? Can we not read the Constitution of the United States? Folks, it's a 3-page document, and then some more. There's a little bit more once you add the amendments, but it's not horrible. Anybody can read it. I don't think they ever did. They read it enough to know where some things were that they could just point out whenever they wanted to make a point. But it doesn't mean it's true. This is obviously grossly outside of the bounds of the Constitution. Anyway, moving on, in 1944, the High Court heard Korematsu versus the United States. Mr. Korematsu was a little upset because he was an American citizen and they had rounded him and his family up, along with several million other Japanese Americans, and put them in freaking concentration camps. Yeah, in the United States, in the middle of the 20th century, under a great Democratic president, Franklin Delano Roosevelt. Yeah, that's the way he talked, remember. A year which will live in infamy. He did it better. I'll just move along. Anyway, so the court ruled that it's completely constitutional to lock away American citizens because of what they look like, because there's an emergency, right? By the way, this decision has never been turned back. It's never been overruled. It's never been changed. Currently, that is United States law. Moving up a little bit to 1962, in the case of Engel versus Vitale, or Vitale, I'm not honestly sure which, the Supreme Court ruled that there could be no praying allowed in public schools. I mean, well, let's take a look at that prayer. It's pretty horrible, right? Pretty offensive. Well, at least to Democrats, because it mentions, God, being trustworthy, being respectful. Oh, and the worst, being responsible, because we don't want anybody being responsible for their own actions, do we? Man, those words are guaranteed to tick a liberal off. You will notice that it says God. It doesn't say Jehovah. It doesn't say Jesus. It could be any God. It could be Vishnu, whatever. I've got friends who are Jewish, Catholic, Protestant. I've got friends who are Muslim. Yeah, amazing, huh? I've got friends who are pagan. None of them have any problem with this. It's God, just God. They're using it. They can say that's a job title. It's not a name. You can take it how you want to, but that's the whole point. The United States was founded on certain religious principles. And to pretend to ignore them is going against the purpose of the Constitution. I mean, let's face it. Let's take a look at the First Amendment. It doesn't say anything about a separation of church and state, does it? Everybody on the left will tell you it does. But there isn't. That's a myth. What it says is specifically, Congress shall make no law establishing or respecting an establishment of religion or prohibiting the free exercise thereof. So, had Congress established a religion? Here's a cute little piece of information for you. Some of the colonial states that signed the Declaration of Independence and signed on to the First Amendment actually had official religions. Seriously. It just says Congress shall not do this. So, they're not going to come out and burn you at the stake if you're a Baptist where it's an Episcopalian state. But they could have an official religion. At least they did for a long time, from 1787 until 1962. They did prohibit the free exercise thereof. At least SCOTUS did when they did this. I guess that doesn't fall into Congress prohibiting free exercise of religion, but I don't know. I don't think any federal office should. And I think that is one of those impeachable offenses. People talk about that mention of separation between church and state, but it's not in the Constitution. That was from a letter written by Thomas Jefferson to the Danbury, Connecticut Baptist Church, and it was taken extremely out of context. It has nothing to do with the Constitution. Last case we'll look at here today is Roe versus Wade. In this case, the court found that there was a constitutional right to terminate a pregnancy. Now, again, I couldn't find any mention of this in the Constitution. I couldn't find anything that seemed like it was a mention of this in the Constitution. Going back to the Declaration of Independence, it talks about, the right of life, liberty, and the pursuit of happiness. Right to life. Yeah, but that's not in the Constitution, even though the Constitution was, according to the founders, written to make sure all of the precepts of the Declaration of Independence could be carried out. Anyway, whether you're pro-life or pro-abortion, I realize a lot of people, whatever the court decides, it can be highly unconstitutional, but if it finds for their side, people want to go, rah, rah, yay! Shouldn't we actually try to found our government, try to base our government on constitutional principles and not, well, we won this case, yay! If you really want abortion, get a constitutional amendment that says it is absolutely allowed anytime, anywhere. The way it was set up before, Constitution, if California wants to have abortion, then states' rights, 10th Amendment, they get to have abortion. If Texas says, no, we want to outlaw it here, then Texas should have the right to outlaw it. That's constitutional. We shouldn't go by what feels good at that moment. We should stick to that document. Anyway, so that's the just part of the SCOTUS hit parade. They've made some boneheaded decisions since then. I just wanted to touch a few of them. I really think there needs to be a constitutional amendment to prevent this. We'll talk about more of that in our next video, about some of the crazier Supreme Court justices and why they needed to be removed and couldn't be. Anyway, I hope you enjoyed the video. Go down below here and give me a thumbs up if you did. If you didn't, give me a thumbs down. That's fine. I understand. Tell me why in the comments. If you liked it at all, or at least find it interesting, I hope you'd subscribe. I'm going to be hitting some really interesting topics coming up. I think you will agree. Also, if you would, if you find what I'm talking about interesting, please give my book take a look at my book. Yes, I have a speech impediment. You'll have to forgive me. It's Radical Freedom. It's by this creepy-looking guy on the cover here. There's a lot of books on Amazon that have the words Radical Freedom in it, unfortunately. So if you do a search on it, it might come up down the list. If you don't see it right off the bat, just do a search on my name. It will come up. If it says it's out of print or something, they're lying. Go ahead and try to order it. I promise it'll come up. And if you can get in contact with me and you want it for some reason, just let me know. We'll work out something where I'll sign the thing for you. Yeah, you may reduce its value for resale. That's the only problem. Anyway, until next time, hey guys, keep being free, keep loving America. Bye.